Welcome. Today we're going to discuss the case of RxD Media versus IP Application Development and Apple. My name is Scott.Slavick. I'm the co-chair of Barrick's Intellectual Property Group. I have over 20 years of experience representing high-profile clients in all types of intellectual property matters. If you ever need help devising strategies to provide maximum international trademark protection for your brands, searching and clearing new global brands on a rush timeline, reviewing new marketing programs, or advising on risks with respect to social media marketing, I am happy to help. In a long-running battle over the mark iPad, the United States Court of Appeals for the Fourth Circuit affirmed the entry of summary judgment by the U.S. District Court for the Eastern District of Virginia in favor of Apple on all claims asserted by RxD Media and on all counterclaims asserted by Apple. The appellate court also ruled that the district court did not abuse its discretion in permanently enjoining RxD Media from all uses and variations of the term iPad and iPod. In 2009, Apple applied for an iPad mark for various business and computer services, including storage and retrieval of data. RxD Media opposed Apple's application based on likelihood of confusion, claiming prior use of the identical mark for providing temporary use of a web-based software application for mobile access database management, whereby users can store and access their personal information. The TTAB subsequently dismissed this opposition. RxD Media then filed a civil action seeking review of the board's decision, and it added 4 more counts, including trademark infringement and unfair competition. Apple joined with its subsidiary as defendants and counterclaimed for trademark infringement and unfair competition. The court ruled in favor of Apple across the board. RxD Media claimed that it began using the descriptive term iPad in 2007, prior to Apple's attainment of acquired distinctiveness in iPad, and so as the senior user of the term, RxD Media could not have infringed a junior descriptive mark. The appellate court, however, ruled that Apple had acquired the right to claim the filing date on January 2002 as its priority date upon acquiring a pending application of Fujitsu. Thus, RxD Media's claim of priority was meritless. As to RxD Media's use of iPadtoday.com, which began in October 2016, Apple had acquired distinctiveness in the term iPad by then, and therefore Apple was entitled to claim infringement by RxD Media by the latter's use of iPad on its iPadtoday.com website. The court observed that even if RxD Media had been the first user of iPad and was entitled to continue using it, RxD Media was not entitled to expand beyond its original product line into an area occupied by an intervening junior user who has established its own rights in the mark. RxD Media's original product line in 2007 was limited to a mobile internet notepad used for creating simple lists. In 2010, Apple released its iPad device, a much different product than RxD Media's notepad. Apple was allowed to assert those rights against RxD Media's rebranding and expansion into website services in 2016. As to the scope of the injunction, the Fourth Circuit concluded that the lower court properly required RxD Media to keep a safe distance from its previously unlawful conduct. Here's an important question that the court appeared to ignore. Even if the Apple iPad of 2010 was a much different product than RxD Media's 2007 notebook, aren't they at least related for likelihood of confusion priority purposes? The takeaway: make sure you have priority before bringing a federal court action. Retain a private investigator to determine your rival's priority date or acquire that information by some other means, because if you file a suit, you are stating your priority date, and if the other side can prove earlier than that date, you are most likely going to lose. If you have any further questions, please feel free to contact me or any of the Barrick lawyers that you typically deal with, and we'll be happy to help you.